Sam Seder, Emma Vigeland on the Majority Report. Real a pleasure to welcome back to the program Peter Shamshiri. He is also known as Law Boy on Twitter, and he is the co-host of If Books Could Kill and the 5-4 podcast, which are great podcasts that Emma loves to talk about constantly.
Hey, I'm a fan.
No, I do. Honestly, like I have one friend who keeps asking me if I've listened to your podcast, and I've told him yes, like 6 times.
I mean, and you guys have like a good podcast format too, where I want to introduce people to more progressive topics or thought points or viewpoints or whatever. So I hand them over to If Books Could Kill, because it's a funny way to like criticize people like Thomas Friedman, for example.
Mm-hmm.
Yeah.
No, and look, I support people continuously asking everyone they know if they listen to my podcast. You got to drive it home.
Right. No, exactly. No, I get it. Without a doubt. All right. In the meantime, let's talk about a couple of the court cases that came down last week. Before we get into that, it's insane to me. I mean, obviously, that we haven't heard about the immunity case at this point. And it's also feels very backloaded. I mean, I think like during COVID, we went into July for rulings because they had to take off a significant amount of time. But this seems, I mean, like, what is your sense of what's going on in terms of that? Or am I making more of it than is really?
Maybe. I mean, it's always worked like this to some degree. It's not crazy to think that they'll polish off the rest of the term this week. 3 opinion days suggest to me that that's what they're trying to do. The only really egregious case is the Trump immunity case, because the entire play is to stall as long as possible to make sure that this does not occur before the election. And in that sense, the case it's over. Trump won. The sort of functional result is going to benefit Trump no matter what the court actually holds. With respect to the other cases, I don't know. I mean, they always stall till the end of the term. It is weird that they have, a 20 to 25% smaller caseload than they have historically, and they're still taking this long, still dragging their feet. But I just think that's because they don't have real jobs. So,
do you think there's friction between John Roberts and Alito because Alito leaked the Dobbs case?
Allegedly.
Well, I'm convinced he did it. So I'm not even going to say allegedly. I mean, he either directed the leaking or engaged in the leaking. And he can sue me if he, I would like to see in Discovery. I would love to see what's going on here.
Well, Martha Ann can't wait. She's
exactly.
Just
she's going to wait for the 5-year statute of limitations or whatever is defamation. But do you think there's any type of friction going on in the court, like around that?
I would say that in general, I would be surprised if Roberts wasn't somewhat irritated by the fact that he has sort of lost control over the PR aspect, and that Alito in particular feels like he can sort of freewheel. He has been leveraging the Wall Street Journal as his sort of PR arm for a couple of years now. And
thank you.
I would imagine that someone like Roberts, whose mission has always been very optics driven, is bothered by that. What it translates to behind the scenes, I don't know. They're always all surprisingly nice to each other in a way that I'm not with any colleague I've ever had. And so who knows? Maybe they're all buds or maybe they hate each other. It's hard to say, but it seems pretty obvious to me that Alito is like undermining Roberts's mission to some degree.
Yeah, I think Robert's legacy is really, impaired. And that to me has always struck me as what's so important to him. And also by Clarence Thomas too. I mean, it is a little bit awkward to be like, hey, wait a second.
Yeah.
How come you have a billionaire that's paying for all your stuff and we don't get one? But be that as it may, let's talk about let's start with the one that impacts billionaires. And that would be the Moore versus United States, which was a Supreme Court decision that was decided last Thursday, people have been paying attention to this because of its implications for the wealth tax. But why don't you give us the facts on it, and then I think we even spoke about this when it was brought up in front of the court. Frankly,
yeah, we may have. The actual case is quite narrow. It's about the mandatory repatriation tax, which is this Trump era one-time tax on like closely held foreign corporations. And this couple, the Moores, they are challenging their tax burden, which I think was something like 15 grand, nothing massive, under the basically saying that this is an unrealized gain and that the tax on it is therefore unconstitutional. This sort of aligns with this longtime conservative argument about taxing unrealized gains and about what's called under the Constitution direct taxation in general. Basically, the Constitution says that indirect taxes, meaning taxes on income, labor, must be applied uniformly across the states, meaning each person must have the same tax burden. But direct taxes, like property taxes, must be apportioned evenly among the states, which means that each state would have to generate an equal amount of tax revenue per capita. This is something that I'm not a historian, but it dates to the founding. My understanding is that it's essentially a slavery era compromise. It's right next to the 3/5 compromise. Basically, Southern states were looking to avoid slavery being taxed out of existence. And so this sort of ensure that would happen, that any burden would be distributed evenly. And conservatives have long argued that this means that like federal property taxes are unconstitutional, or at least functionally unconstitutional, because you'd have to institute this elaborate system, and that the same applies to wealth taxes. And so a lot of conservatives were looking for the court to go very far here and say all taxes on wealth are going to be unconstitutional unless they abide by the apportionment system, which would, again, be basically logistically unfeasible, or at least very complicated. The court didn't do that. They sort of very intentionally, very consciously sidestepped the issue, and Kavanaugh writes a majority that basically says we're not touching that issue quite yet, but very heavily implies at the same time that when they do eventually reach that issue, they will side against a wealth tax.
Let me see if I just understand this in terms of the direct and indirect taxes, because the indirect being you're not taxing the person, you're taxing their activity. So if you work, we're going to have a payroll tax, 6, 7%, 8%, I guess it is now, and your employer has to pay for the other half of it. And it only goes up to the first $120,000. How? And the direct tax has to be apportioned between the states. Is that it? I mean,
by population. So it would have to be the same per capita across the states.
Okay. So, and that would be difficult to do because you have money concentrated. Let's say if we did a wealth tax and we said across the board, if you have over $50 million, you owe 75% tax on it. I mean, if it's up to me, I would say 90%, but let's just, whatever it is. New York State would end up paying a lot. There'd be a lot more money coming out of New York State. I mean, I guess that's just the way it is. They would have to go by the state functioning, or Florida, I guess, would be, wherever someone are escaping. So is there a way around that, though? I mean,
there have been proposals. I will not say that I understand them very well, but there have been proposals. The real problem is that most taxes, as we understand them, are just, here's X economic activity, we're going to tax it at Y rate. Whereas this would have to have some sort of, it would be sort of reverse engineered, because you need the outcome to be a certain rate per capita for each state. So it would have to work very differently from normal income taxes. It probably can be done. But if you look at like the Bernie Sanders, Liz Warren proposals coming out of 2020, those would be unconstitutional.
And also, to be clear, I mean, I just want to clear this up because this comes up. The idea of taxing unrealized gains, we do that, or states do it. So it's not impossible to do. I mean, I don't know how much someone's house is worth until it actually sells. Particularly, like in this market, in Brooklyn, it's crazy how much stuff sells for. But you take a guess. And then, that's it. There's an assessment that's made. And that can be done from afar. This isn't that complicated. People say, like, what about artworks? Well, I mean, when you take it to Sotheby's, they have a notion of how much it's worth and where they're going to start the bidding. Okay, I'm okay with, lowballing a little bit of some of these paintings. That's okay. As long as we get to the heart of like where the big money is.
In general, that whole like direct versus indirect thing has never made a ton of sense to me. There's this story that's famous among nerds where at the founding, someone asked the question, hey, what is a direct tax? And no one answers. So I don't know that there's like a clear definition. We've sort of decided, and the Supreme Court back in like the 1890s decided that this is property taxes, for example, taxes on wealth. But I don't see how taxing, for example, unrealized capital gains is more direct than taxing dividend income, for example. It feels like a very sort of abstract difference.
And theoretically, a court, long after I'm passed away, I guess, if there's an opportunity for a different sort of a breakdown on the court, could redefine what direct taxes are, right? I mean, since we've never had an actual issue involving them, it's completely theoretical.
Yeah, I think that's right. I mean, again, it doesn't really mean anything inherently. The regime that it was sort of describing at the founding isn't one that meaningfully exists anymore. So in my mind, it could be reinterpreted and should be reinterpreted, and probably should be ignored for most purposes.
You could also theoretically, just one final thing too, is to say, okay, we can't, the federal government can't tax these billionaires directly. So what we're going to do is your highway funds, your Medicaid funds, your whatever federal subsidies you get are all going to be contingent upon you collecting this tax. Uh-huh. And you could have the states do it, right? As basically as a surrogate.
Yeah, I think so. I mean, this Supreme Court probably wouldn't allow it. They would say that you are bullying.
No, they wouldn't even allow you to expand Medicaid.
Right. Right. But yeah, I mean, absolutely. That's a possibility under a normal human Supreme Court.
I mean, Ronald Reagan said if you don't drop your speed, your maximum speeds to 55, or I should say, drop your drinking age, I think it was, or raise your drinking age, to 21, you're going to lose your federal highway funds.
Yeah.
And, the rationale, I guess, being that people are going to die on the highways or whatever it was, but that's pretty far afield. All right, let's move on to the other court decision that we heard last week. This was U.S. versus Rahimi. Did I say it right?
Yeah, I think so.
Okay.
As far as I know.
This one was a bit of a mess, wasn't it?
Yeah. Well, it's a mess that the court put themselves in. So yeah, this is about the constitutional right of someone with a domestic violence restraining order to own a firearm, which is, it's weird to say out loud. Basically, this is about a guy who had a violent conflict with his girlfriend, pulled a gun, fired a shot either toward her or a witness, we don't know, and then was a suspect in multiple shootings over a pretty short period of time. 6 different shooting crimes. Yeah, one of them was firing a gun into the air when his credit card was declined at a restaurant. So that's, yeah. That's the only
He's a
one
good
that's
American,
funny.
Peter. I mean, come on, exercising his First Amendment rights there, or Second, Jesus.
If he'd been able to throw it up in the air and hit it while he was firing, that's. I mean,
That's
Yeah, no,
extreme
that
circus
should be
act.
legal.
Yeah.
I mean, so this guy, gets the girlfriend gets a restraining order, and then this guy challenges it, basically saying, I have a Second Amendment right. The twist here is that in 2022, while his case is pending, the court hands down NYSERPA v. Bruen, which says that the test for firearms regulations under the Second Amendment is that in order for them to be constitutional, you need to show that they are consistent with our nation's tradition of firearm regulation, which in practice, they say, means finding an analogous law from the founding era, which puts this huge burden on the government in all of these cases, including this one, to find a law from the founding era that looks like the law that they have passed to regulate firearms, which means, in this case, finding a law that looks like telling a guy with a domestic violence restraining order, which is something that really did not meaningfully exist at the founding, that he can't have a gun.
okay, there's multiple things I got to stop you here and ask. First off, let's work backwards. Was domestic violence even a legal concept at that time when your wife was your property?
Mm-hmm.
Yeah, not really. There were sort of these restrictions on interpersonal violence that could apply to marital relations and relationships at certain times, but domestic violence as this like discrete thing didn't really exist. For the record, there also there weren't rates of like murder, for example, in marriages that we're aware of that are anywhere near what we see now. It might just be that we're looking at bad reporting, underreporting, but it's sort of, there are just not a lot of parallels, right? Like the whole legal structure of marriage was different. The sort of like the access to weapons for the median person was wildly different. It's just not a similar situation to anything that you saw in the founding.
What is the founding era? Like, how do we determine? Like, I know when the Constitution was signed. I know when the Declaration of Independence was signed. But what's the legal definition for an era? Is it 5 years? Is it 10 years?
So Thomas in Bruen doesn't really explain this. He basically examines the period from the founding itself, like early 1790s, through the Reconstruction Amendments, or up until the Reconstruction Amendments. So we're looking at an era of 80 years. Amy Coney Barrett writes about this in her concurrence a little bit, that basically implying like we need to figure that part out at some point.
Yeah, like, because 80 years, like that's the era. Like, I mean, that is just, it's completely made up.
I mean, the test is so ridiculous that it's hard to harp on one part of it as like notably dumb. But I do think that like the era concept doesn't really make sense. We're talking about several generations passing. The Thomas decision in Bruen talks about all these laws throughout this era, but it's sort of unclear what weight we're supposed to give to different time periods, whether the founding itself or right before the founding is supposed to be like the time that we're focused on, or whether, it makes more sense to focus on, the 1860s when we've had 70 years of the Constitution existing to build on. No one knows. I mean,
what if it was like determined based upon like garb? Like we just did it like if they dress alike during that period or something to that effect. But let me ask you another question, because the whole gist of this, it seems to me, is that this is a completely, well, first of all this originalism is all made up. I mean, it's made up, but not even like everything's constructed. But this is like constructed without a foundation. And it's like, you come into the house and you find out like they didn't insulate this at all. And wait a
Right.
second, they don't do 16, on center for the studs. They just do it haphazard. I mean, the whole thing is just so made up. But why wouldn't you apply this concept to, let's say, I don't know, like free speech? Because you know what there also wasn't during the founding era? Radio, TV,
Right.
internet. Why does free speech apply to radio, TV, and internet if it didn't exist at that time?
I mean, I think the case with free speech is even worse than that. I mean, in the founding era, broadly defined, we had the Alien and Sedition Act, right? I mean, the common understanding of free speech was completely different at the time, and I think there's like some concern that they start building this history and tradition concept out across the Bill of Rights, and you see free speech get whittled away on that basis. I mean, what Thomas says in Bruen and is reiterated in Rahimi is, if you can't find a perfect analogy for the problem being addressed by the legislature, that you can use more distant analogies, but the more distant they get, the faker it becomes. And I think the real story of this case is that the conservatives sort of reveal that they embarrass themselves by trying to do this, that they spend 40 years developing this theory of originalism. They finally get the chance with the 6-3 supermajority to start putting it into practice, and they build this history and tradition test out, and their first real attempt falls apart immediately, and they have to return 2 years later because some guy who's firing gunshots in restaurants when his card gets canceled now is claiming he has a constitutional right to a gun, and he sort of has a point if you read their prior cases.
I mean, this is so when I read into all this, it is so analogous to like debates I've had with libertarians, or like getting on, calling into a right-wing talk show, and they allowed me, like, they have been in their bubble for so long that the rigor associated with developing this theory, which has existed for, I mean, decades now, there's been no rigor. And so they haven't had to address even the most basic application of this. And that's why, like, apparently, like, all these subsidiary courts are writing back, like, we don't know how to apply this standard because it's not a standard. It's like, it's like, I don't know, somebody walking around tasting different wines and giving a sense of like whether it's fruity or woody or whatever it is. Like, there's no standard here at all.
Yeah, I mean, if you look at the lower courts, and usually the Supreme Court will hand down a decision, see how the lower courts are handling it, and then maybe like a decade later, they might step back into the fray, right? And clarify some things. They come back 2 years later in this case because it's been such a disaster in the lower courts, because you have courts holding that, for example, there's a constitutional right to scratch the serial number off of guns, that age restrictions of certain types are unconstitutional. Assault rifles have been found, and high capacity magazines have been found to be constitutionally protected by several courts. So there's just a lot of chaos in the lower courts. It's the direct result of their standardless, like, bizarre decision in 2022 in Bruen. And this is the court sort of, without saying it, because they do blame the lower courts. Roberts immediately is like, there's been a lot of misunderstanding about our decision in Bruen. So they won't really admit it, but this is the result of the court messing it up. That's why there's 5 concurrences. There's 3 concurrences from conservatives alone, just sort of desperately trying to explain themselves. And that's not even counting the Thomas dissent, because Thomas thinks that this is in fact unconstitutional.
So, but is there any more? I mean, if I'm a lower court now and I get this Rahimi case, and I've had problems applying Bruen, and I get this Rahimi case and I look at it and I go, I am at exactly the same place as I was 3 weeks ago.
Yeah, I think what Roberts really did with this majority opinion was broaden the standard rather than clarify it. So previously you had courts looking for analogous cases that that can uphold a regulation, and if they can't find one, they strike it down as unconstitutional. That's pretty much what Bruen told them to do. Here, Robert says, look, you shouldn't be so focused on cases. You should be looking at the broader principles, which, by the way, is like a little bit less originalist, a little bit more like living constitutionalist.
I mean, isn't that like almost definitionally like not originalist? Like
more or less, I mean, he acts like, of course, that this was what they meant all along. But I don't think that he provided any clarity at all. I think what he did was provide the flexibility that some of the lower courts need to have an off-ramp from some of these more like ludicrous outcomes so that courts can stop saying, hey, this is unconstitutional. However, this is an absurd result. Someone please help me, because several federal courts wrote that decision.
Does this, do rulings like this degrade? I mean, I have a certain amount of skepticism about sort of all of it in terms of like this is canonized and, the idea of like, we don't look for an outcome and then reverse engineer it. And, but lower courts in particular, obviously, there's more standards. They know they're going to get reviewed. And so there are some like sort of parameters for them in which they operate. But it feels to me like this sort of like degrades that it spreads the disease that exists at the Supreme Court where they just make up stuff. And it basically says like, we can't come up with parameters. So we're just going to basically say, you guys make up stuff. And if it's really, really a problem, we'll step in. But in the meantime, it's whatever disease we got, we're going to give it all to you on some level. That's what it sort of feels like. It's going to degrade the lower courts too.
Yeah, I mean, I'm not sure if it degrades it as much as it like reveals how sort of completely fictional a lot of these tests are. I mean, the previous test, the one that really dominated across the country was a balancing test, which is sort of how almost every constitutional right in the Bill of Rights works, that you would say, what's the government interest? What's the right? And let's balance those out, right? Now that's just as much a matter of the court's opinion as like the principles of the founding era or something broad like that. But I do think that like,
but you can measure that, leeway, right? But you can measure that. Like you can say, like, okay,
it's better. First of all, it factors in the government's interest, and this doesn't.
Right. I mean, you and I could disagree, like how much it's actually in the government's, but we have to articulate it. We actually have to make a case. Like saying that this is you could just sort of make that out of whole cloth. I mean, like it's just as valid to say, like, there was no domestic violence back then because, everything was violent. It was violent on the prairie. And so, I
don't think that these are like substantively equivalent, but I do think that, and to be clear, I think that what the court is doing to some degree is giving weapons to conservative courts, right? Because the principles, broadly speaking, that existed at the founding were more reactionary principles than exist today. And so, generally speaking, you're going to see more reactionary outcomes, right? And what their goal is to erase the government's interest from these calculations. And they've always hated this. They've always hated balancing the right against the government's interest in these cases because they don't care about the government's interest in Second Amendment cases. And I think that that's what one of the goals of these sort of originalist tests was, not just to sort of like focus on the founding era, which they had already been doing to some degree in their jurisprudence, but to just wipe the government's interest out of the equation altogether.
All right. Let's just lastly, there was this case, Department of State versus Muñoz. There's some people who, have, one of them is Sonia Sotomayor, that brought up that the decision in Muñoz could be a path to reversing marriage equality in some fashion. God bless you. What is your sense of that?
I'm not sure that they need to forge a path for themselves.
Right.
I do think that if in 3 years, for example, Obergefell is overturned, you're going to see a citation to Muñoz. Like, that's just how they operate, right? They sort of create their own justifications over time. I mean, the court's language in this was pretty dismissive of the 14th Amendment liberty interest in marriage, and that is what Obergefell is predicated upon in part. So it feels to me like that's what the court is hinting at. I think Sotomayor is sort of correct to be concerned. I think that my concern about marriage equality exists outside of the context of this case. I think this case is more of a symptom of the disease that will eventually, if untreated, lead to the overturning of Obergefell. Right.
I mean, I think there's a clear sense that they are heading in that direction, and every now and then they may leave, I don't know, some utility, the tool by the side of the road for them to come pick it up next time they come down.
Yeah, all they need is a couple little sentences to quote, and that allows them to feel like they're doing law, and then they hand down the decision that they want to hand down. I think that's where they're headed here. Whether they overturn Obergefell, to me, is almost entirely a matter of political appetite. Is Kavanaugh in for it? Is Gorsuch in for it? Who knows?
Based upon the last question, we heard that Martha Alito tape. And one of the most interesting things coming out of it is that she's talking like Alito is going to be off the court within 5 years, so that she's going to go hog wild on all her defamation suits. Yeah. Particularly that woman from 20 years ago who said that, criticized her outfit or whatever it was.
Right.
Do you think that there's going to be, like, in the event that Biden wins, assuming it's going to be Biden and Trump, that Thomas and Alito are going to be fighting over who gets to retire? I mean, how many millions of dollars will Harlan Crow have to pay Clarence Thomas to stay on the Supreme Court? Like, obviously not directly, but I mean, how many, I don't know how many family members that Thomas has that he can have houses bought for. But what do you, what would you say the dollar figure is?
I think they hang on, first of all. I do think that Clarence gets, you have to factor in inflation in the gifts, know. So I'm thinking $1 to $2 million over the course of a Biden second term. Clarence, you have to keep in mind with Thomas in particular, he is energized by the rise of fascism. Like, remember when he went almost a decade not saying anything?
Right.
And then Trump came along, and all of a sudden he's like, he's got the spirit Unleashed. A little bit, right? Yeah. Now he's chatty. Now he has an energy behind him, and I think Biden term 2 keeps him energized. I think he gets so mad thinking about Joe Biden that it keeps him going every day.
Well, Peter, I'm going to say I think you're lowballing it, because if I'm Clarence Thomas, $1 to $2 million, that may be a little bit in regards to inflation. But I also know, like, these are desperate times for the Harlan Crows. You're going to need this. So I'm going to say, $4 to $8.
I mean, look, you might be right. And some of that could just be paid to Ginny, some political consulting. Why go the gift route when you can just hand it to whatever weird little LLC Ginny's got?
It's both. It's called the limited hangout. That's why. Look at the free trip he got. Meanwhile, she's making like $16,000 an hour, sending out mailers for Hillsdale College or something. Peter Shamshiri, thank you so much for coming on. We will put a link to both If Books Could Kill and the 5-4 podcast, of which you co-host both, and encourage people to keep asking your friends if you've listened to them.
Yeah. Thanks for having me.
Thanks. Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.